Good afternoon, everyone. I see that. Oh, there we go. There's Bruno. Good afternoon, everyone. I hope that you
Hi.
all had a. Hi, Bruno. I hope that you all had a fabulous week. As you can see, I am in my informal Wednesday attire. Nobody gave me the memo that Cape Town, because I'm in Cape Town right now, that you could bring ties and shirts to Cape Town. So
I don't think you can you?
no,
Is
that's
it
why I'm dressed
allowed?
like this. No,
Yeah,
it's not.
exactly. They strip it off when you arrive at the airport. They're like, no, sorry, no,
Yeah.
just wine here.
Yeah, I feel so underdressed. You guys always look fabulous, man. You look like you. Oh. But yeah, welcome everybody to another Wednesday webinar with the Property Law Alliance. It's good to have you both, Bruno and Solna, with us. Bruno, how are you doing?
I'm well. How are you doing? Being Cape Town?
Yeah, I'm pretty well. It beats being in dry Johannesburg. Well, although I love Johannesburg, it beats that. But we're not going to get into a battle of provinces now. Solna,
I think you need to show everyone your view.
Please do.
I think I do, actually. Let me do this.
I'm jealous.
This is where I am. Yeah,
No.
that's Camps Bay. Oh. Not bragging or anything. Anyway, Solna, how are you doing?
I'm good, thank you. Jealous of you in Cape Town, but at least I think if I ask nicely, I can potentially get a glass of wine, which is sort of like Cape Town, but you have a very pleasant view.
No, but it's lovely to have you guys, and it's lovely to have the viewers with us as well. We have a jam-packed session this Wednesday, so I'm going to get straight into the first question, and this is a question that was asked by a gentleman by the name of Mohotsi Azaya. Mohotsi asks, or rather says, that he grew up in his grandmother's house, and he lived there initially with his mum and his uncles. And then he says over the years, everyone left with the exception of his grandmom, and then sadly she passed away. And when she passed away without a will. And he says that the family then agreed, look, Mohotsi's been here for a number of years growing up in this home. He should live in this house. So Mohotsi then lives and carries on in the house. And then he does renovations. And I think, according to his words, he built the house from the ground up. And then fast forward a couple of years, the family comes back and says, no, Mohotsi, you got to get out of this place. This is not your house. You got to get out. So rather than put up a fight, he leaves. His question today is, what recourse or what rights does he have in terms of this property, bearing in mind that his grandmother passed away without a will? And then also, I mean, Mohotsi put a lot of work into this house by the sounds of things. He's renovated it or built it and done some improvements to it. Does he have any right to the improvements that he's done? So I greeted Bruno first. I'm going to throw this one to Solna. Solna, what
Why?
do you think
because are you throwing it to me? Because I'm almost tearing up on this one.
Shame, man. Yeah, I feel for Mohotsi in the situation.
I really do, and it's even worse to give the answer because you have no legal right to the property or to the improvement. So let me expand a little. Because your grandmother passed without a will, so intestate succession dictates then that her spouse, if she had a spouse, will receive a portion of her estate, and then her children, and if she didn't have children, her siblings through her parents are the only heirs. So obviously she had children, otherwise Mohotsi wouldn't have had this question. So the children receive inheritance if they are still alive. Interstate succession then dictates that the inheritance stop there. If they are predeceased, he could have a claim to a portion of the estate. But the only scenario where he will have full right to the estate in the context of interstate succession would be if her spouse is predeceased and they didn't have any other heirs from that side. So her spouse, which is predeceased, didn't have any children outside of their marriage. So the only heirs that they have are the children born from their marriage. The spouse is predeceased. Also, Mahotsi then doesn't have any siblings, and both his parents, the parent that links him to this grandmother is predeceased, and he's the only one. In that context, he would be the heir of the property, but he already makes mention of her brothers because he says uncles. So my assumption is his grandmother's brothers. So already in that tree, I'm seeing predeceased parents of the grandmother with then potential siblings. And the truth is, the statistical chance from not having all the data and not having all the information, but from what I'm hearing, interstate succession, if Mahotsi is lucky, he might be entitled to a small portion of her estate. Unfortunately, to deal with an estate like that, where you get a portion, like we discussed last week, the week before last week, on 50% ownership of a property, you can't shave it into pieces and say, okay, like Mahotsi, at least you get the kitchen. That's not how it works. So unfortunately, the property will have to be sold. And to add to that, any improvements made to a property is pretty much a claim in lien. So you have a right to either retain payments that you've made or hold on to the property in a way until that is made. But the rules around a claim in lien is very strict. The improvements had to be necessary improvements. So we're not talking building a property from scratch. We're talking necessary improvements. Most of the time, that will not be allowed. So the only other potential claim I can see is undue enrichment. And the truth is, building on a property that is not yours, you're not entitled to undue enrichment, because imagine that disaster on land grabs. You just start building and you're like, yay, I made it pretty. You hate it and you didn't want it, yeah, but you know, at least I built it. It's not about aesthetics. It's not about anything. You're not entitled to build on another person's land and then claim from it. So Mahotsi, I'm sorry, I think you're the first question since we started the webinars that got me in the emotions there. But it's sad for me to have to say, unfortunately, the money that you've spent on the property, you don't have any claim to get that back. And unfortunately, unless I see the full details on the family setup, but already from my what I'm hearing, I can't see that you have any claim to the property. Bruno, please give me some form of light at the end of the tunnel.
Look, so there's a couple of things, there's a couple of considerations here that may assist, and a couple of things that that definitely won't. So just to kind of build off what you've said, because you've pretty much done all the groundwork on the interstate succession aspect of it. The odds are slim, and we have to deal with odds because we don't have enough information. But for a grandson to inherit, is already tough. But to have the sole inheritance, the property as its sole inheritance, is even more tough. So the odds are very slim that that's actually the case. So now let's take it up a notch and let's start thinking forget about the deceased estate. Assume that in terms of interstate succession, the property was left to someone. So somebody within that family is apparently entitled to this property and has some title or interest to it. It's whether a transfer was passed or not, we're uncertain, and we don't know who that person is. But there has to be someone, right? It might have been an uncle, for example. Now, that person is in control of this property. And if that person was the one that made the decision regarding allowing him to continue occupying the property, we would just have to look at that, because that is effectively an agreement. So why would they let him occupy the property? Because the reality is it's not a simple hijacking story of, well, the person's there, we don't know what to do with him, so we left it for 10 years, but now we're changing our minds. I mean, from the sounds of it, there was an actual express agreement to say, well, stay on the property for as long as you like, for the age of majority until you get on your feet. There's always some sort of condition attached. And even if the condition wasn't all that express, there's definitely a value to this. And we just kind of need to figure it out. And this is where exploration in the form of mediation, for example, comes into place, because there was a real agreement as to occupying the property. Not necessarily that he was going to be owner of the property, but one would also need to explore this. But remember, passing of ownership and sales have to be in writing. So you're not going to get away with saying, well, they were going to donate the property to me, because that whole transaction would have to be in writing. So that wouldn't apply. So we're looking at some form of right of occupation. Obviously now he's left the property, but during that right of occupation, what were the terms of it? What I do tend to find, and you find this a lot in building contracts, especially when it comes to infrastructure and things like that, but even in general, in buildings, whatever the case might be, people occupy properties in exchange for something. So typically, the value of occupation is some form of rental. Occupation has a value to it. You would have to pay something to occupy another property. So why aren't you paying to occupy this property? But if rent wasn't asked from you, then something else typically would be some form of consideration. Was that your cat?
That's my cat. I'm sorry. She almost ran into my wife. Sorry, serious.
No. Bruno?
Carry on, Bruno.
Feel free to go ahead.
Cool. So that occupation carries a value to it. What was the consideration for occupation? And that's kind of what we need to ask for now. Was it simply supervising the property, making sure that no one vandalizes the property, that no one hijacks the property? I mean, I've seen occupation be that value many times, where you just want to stick someone on the property so nothing bad happens to it, right? So a level of security or act of possession, could actually be enough. Some people improve properties. So some people actually go there, make sure that it gets maintained, and they do small improvements in exchange for which they are remunerated effectively by occupying the property. So that's one thing that he will have to consider, is the potential that there was some kind of trade-off, and he can't ask for anything because he's effectively already gained something for his occupation. However, that being said, since we don't know, the other thing that we need to look at is the liens that we were discussing, and enrichment liens. Now, the funny thing was, so Silna's on point with that. So the funny thing with enrichment liens is, if you go and do, especially when it comes to enrichment, if you go and take care of somebody else's property. So this is, it touches on enrichment. But there's also another principle in our law, negatorium gestio, which is handling the affairs of others. So with the combination of these two, it's a very strange type of scenario. But effectively, if somebody goes and deals with the property, improves it, increases its market value. So now this is important. What you spend on the property versus how much you increased the value of the property by are two very different things. So my typical example is, if you go to a flat in Hillbrow and you install granite kitchen tops, you're spending a fortune, but you're not increasing the value of the property, because typically your ideal buyer, your target buyer in those areas, will not want granite tops. So you're overcapitalizing and you're losing a lot of value. So just because he installed, I've got no idea, I can't think of an example, but in the backyard, possibly a little lapa, and it cost them X, in that area might not be something that people typically look for in a house. So when they perceive value, they perceive it as half the amount. And when it comes to this enrichment lien, when we're dealing with this, typically what you'd find is, he would have a claim to say, well, off my back, you were enriched by X, because the market value of the property increased. So at the very least, I can't claim back my expenses, but the difference in value is something that I would be entitled to, right? And we're dealing with a claim like this now recently where that very same thing has happened, where the guy put in 1.4 million into the property and he's saying, well, you need to give me the 1.4 million. The problem that I found there is exactly with the overcapitalization. The property is going on market, we can barely get 600,000 for it. So he's not coming close to getting what he put into the property. And that's the reality with it. And then the second thing that he needs to remember is even if he manages to prove an increase in market value, what about his rental? Because then somebody might say, well, you owe us rental. And there the trade-off comes in. So light at the end of the tunnel, maybe, but it depends on the maths and people's kind of acceptance of value and things like that.
Okay. No, thanks for that information, guys. Mahotsi, I think if you need more information, please do contact us again, and feel free to contact one of our experts on the panel today. I'm going to move quickly over to the next question. And this question it's very interesting from both sides of the spectrum, whether you are a lessor or a lessee, a landlord or somebody who's looking to rent a property. And the question is, fundamental of a lease agreement, one of the fundamentals is that when you enter or sign on the dotted line that you're going to enter into this lease agreement as a landlord and the lessee, is that you will conduct an inspection. It's when you enter the property, the two of you meet, the landlord and the tenant will meet, and they inspect and they look around and they draw up a snag list and they put down all the issues on that snag list, right? That's when you're entering it. And then also when you're exiting a property in terms of either the termination of a lease agreement, cancellation of it, you will similarly do a similar inspection with the two parties who contracted together being present. Now, the question is, what is the importance of these inspections, and what are the pitfalls and risks in terms of not conducting these inspections the way they ought to be done? Now, the question will be in two parts. The first will deal with your retail and industrial properties, and the second will be with regards to residential. So I'm going to go and throw this one to Silna quickly with regards to the residential properties, and then we'll touch Bruno on the retail and industrial. So Silna, please can you let us know what?
Well, let's see if nothing weird happens. Like if the cat stays put, the kid stays put. Things are happening in this house tonight. So let's see if we can get through this one without entertaining things. So residential is not something that is sort of dealt with in terms of the lease agreement. How the inspection is conducted, when it should be conducted, is all legislated. And the act where this is coming from is the Rental Housing Act. The thing is, remember, for the benefit of our viewers, you can never, ever, ever, ever contract out of legislation. You can contract around a lot of practical things, but you cannot contract out of legislation. If the act says this is how an inspection should be done, when it should be done, that is how it should be done. And what you agree to in terms of your lease agreement is irrelevant. So the inspection and the viewing must never be confused. The viewing is when you go to a property to check it out and you're like, oh, yeah, this is, whoa, a lot of stuff against the walls, but I can, at least I can take that off. But you view the property and you see if you can actually live there. You do basic checks, and I recommend that always for both agents as well as tenants. Turn on the plates on the stove, check the oven, check if the geysers are working, check the water pressure, please, guys, because that's not a problem thing that the landlord has to fix. Open the tap, see if it's running, see if the water gets warm, stuff like that. That's a viewing. That is when you see that, yay, I do want to rent this property. You do your rent application form. If your application is successful, you then sign a lease agreement. Still no inspection. Inspection in terms of the Rental Housing Act must be done on entry or before entry and moving into the property. You can't do that inspection too far from the date that you are actually taking occupation. They have to go inside. The act is not clear on like how far from entry, but basically on entry. So the same day before, you do an entry inspection. That inspection is a recordal of the defects to the property. And Chris, I don't mean to correct you here, but I just want to point out, using the term snag list is actually something that comes in on sales. So when you snagging by definition means there is a defect that has to be repaired. This is not the intention of the inspection in a rental. The intention of a rental in an inspection in a rental is to document and record the defects. Because let's take a quick example of the wall that you guys see every Wednesday. When I move out of this property, I'm going to have 1.5 million little spijkertjies and holes in the wall. Okay, a fun little fact, a tenant will actually be moving in here, and I will note that, and I will say there are 1.5 million holes and spijkertjies in this wall. When the tenant vacates, I can't say, excuse me, tenant, love, don't you please just want to fix the spijkertjies and the holes that you have in the wall? No, that was a landlord problem. So the inspection is done to record the defects. So the landlord cannot hold the tenant responsible for defects that wasn't caused by the tenant or by fair wear and tear. Because if you inspect a property and you see, this window thingy is on his last legs, note that. Because when the window thingy, my terminology on house hold stuff is amazing. It's not it's like my Latin, spijkertjies and thingy. That's sort of the thing. Try to record it better in your inspection sheets. But if that window, what am I talking about? That thingy that keeps him open? You guys must know. Oh, you guys are going to say thingy as well.
It's the thingy. It's the thingy by the thingy. But that's how you record.
The thingy by the thingy of the window. So if you record that the thingy is on his last legs, when he then breaks, it's easy to say, Mr. Landlord, that was fair wear and tear because he was already on his last legs. You can't expect the tenant to fix your wear and tear. Now we know what's going on. Exit inspection. What I just want to add, a tenant can never, ever, ever expect a landlord to repair the things that's recorded in terms of the inspection. If the window thingy is not lacquer, the window thingy is not lacquer. If the tenant wants the window thingy fixed, he should have said that before he concluded the lease. And then fixing of the window thingy must have been recorded in a special condition. If it wasn't, the landlord has no obligation to fix that. The tenant can then on exit say, but these are the defects, let's compare the list. This is what I'm responsible for, but this I'm really not responsible for. Landlord always responsible for fair wear and tear, maintenance and these kind of things. Tenant responsible for cleaning and maintaining and responsible for short-term consumables. But other than that, definitely nothing. I see landlords pulling unfortunate moves. For instance, we all know a residential property, inside typically painted every 5 years, outside 7 to 10 years. If your tenant that occupied year 4 and 5 moves out and the paint is now not lacquer anymore, the landlord has to appreciate that it's a maintenance obligation to paint. And you can't put that wall now on the last tenant's, in the last tenant's corner. That paint wasn't 100% when he moved in. Fair wear and tear dictates that when the tenant vacates after year 5, even if there's then some damage to the paint, for instance, some scratches as they moved and stuff, you anyway have to paint, Mr. Landlord. And landlords, you know, I'm usually on your side. So hear me on this one when I say this is a you responsibility, a landlord responsibility. Exit inspection in terms of the act has to be conducted within 3 days prior to exit. Now, let's quickly pause. Legislator, with all respect, What have you ever done an inspection while people are moving? Again, respect legislator, but goeie genade. What I usually advise clients is, and agents, arrange the inspection in writing within 3 days prior to vacating, but please try and do the inspection once the property is vacant. I can, if I move out of my property, I mean, there can be a crack behind that thing the size of the Grand Canyon. Nobody will know about it. So do the inspection when the property is empty, and please be fair. We actually all know what the defects in our properties are. And as landlords, we really know what the defects are. And we really know what the things are. We are like praying, please, please, Giza, last, just get me through. Just get me through this last tenant. You know what it is. So let's be fair to one another. But the act is quite clear. On the exit inspection, arrange 3 days prior to that. And please do all of that in writing. Mm-hmm. Inspection can be done virtually. Inspections, there are amazing software, Home Inspect, companies like that, amazing inspection companies with software to record it properly. Take photos. Don't take photos of a crack with no any form of reference to it, to put a ruler next to it. Take a photo. So when we have to compare, even the most amazing brains, I can't remember the size of a crack a year later.
Of course. No, thanks, Solna. I think, Bruno, we're going to throw it to you with the retail and industrial spaces.
And I've got 1 minute to do it.
No. We'll give you some time. We'll give you some more time there. This is on me to you.
No, thank you. I appreciate that. So let's try keep it short. There are substantive differences when it comes to any sort of commercial space, right? And the reason for this, for starters, is the fact that your typical legislation that protects housing and consumers in housing don't apply. Why is it, you may ask, that housing consumers have protection and businesses don't? Well, it's simply because of that. There is that component of sophistication or a level of knowledge when it comes to the ins and outs of how things are supposed to work. So as a housing consumer, then the South African government, the Constitution requires almost a higher level of protection. It's integrated into our law. Many laws focus on those consumers. That's why even when you look at CPA, for example, you'll find that a natural person, so you and me, we have a lot more protection under the CPA than juristic persons do, and National Credit Act, very similar aspects. So juristic persons are expected to have a better sense of what's going on. So that's already one aspect. So the legislation is not the same. What this typically means is that a lot is governed by way of contract, right? And so some legislation does apply. Yes, certain contracts are protected by virtue of the Consumer Protection Act up until certain points. But beyond that, we then start looking at the contracts. What do the contracts say regarding the governing of the property, the inspections and that sort of thing. And what you do find is there's a lot of similarities. So they do take certain timeframes, for example, and they implement it into these contracts, saying that before you move in, for instance, you need to go through this commercial property or office space or retail space or whatever the case is. But the reality is that if you go and take a retail space, there's going to be shop fittings. There's going to be complete changes to that space. So no one 3 days or a week before goes in with a little list and starts, pointing things out. In fact, half the time, unless you move into something that's fit for purpose, half the time you want it white boxed, and that effectively means that it's completely empty. So as long as the pillars are in good order, the windows all open, and the piping works, you're good. So it's almost easier to do these inspections because a lot of the work is actually done by the tenant. And interestingly enough, when you move out of these type of spaces, a lot of the contracts actually say you need to put it back in the position it was in, the state it was in. Reason for that being the fact that you don't, a lot of shop fittings, again, are very specific. So yes, you might get lucky and the next tenant happens to be a firm of attorneys that need a reception and a couple of offices and a conference room, right? Or it used to be a butchery and now you're opening an office in it. And those are two very different things. And there's usually an obligation. What is it? Similar things, Sona?
I'm saying a law firm and a butchery isn't that far from each other, is it?
Yeah, so and because of that, the tenants in commercial spaces typically are required to get almost white box or put it back into the state it was in when they found it. And exit inspections would then be very similar to that. And would be according to that. So at what point do they stop business? At what point do they get it back in that position? And after that, you would then in the contract probably have a period of time that would govern your exit inspection just to make sure that it is in fact the way that it's supposed to be. That's the short answer.
And I think if I may now steal another minute, you mentioned the white boxing, and I think a lot of businesses and tenants in business parks or commercial, retail, industrial not that bad, but commercial and retail. Goodness, I think a lot of tenants do not understand the cost involved to white box a place. It is crazy expensive. We were lucky enough, funny, that's why I laughed. We were lucky in the office where we are, and we've been there now for 5 years, but we actually evicted the previous tenant. And I obviously knew what the office looks like then. And I'm like, I want that one. The shop fitting, everything is perfect for my office. I want it.
Was it a butcher? Was it a butcher?
Luckily not, but it probably could have been, and it was perfect the way I wanted. So our tenant installations were pretty cheap. But I think a lot of tenants, especially if your TIs are cheap, your tenant installation, you might not appreciate how expensive it is to white box. To white box our office, a 418 square office, is going to end up costing us at least 200,000 Rand, because you need to take the tiles out, you need to repaint the whole place white, you need to take your partitioning out, everything. And it ends up being a pretty expensive exercise. So that was just my 10 cents on the commercial side. Tenants very often are super sad at the end. You have to pay like 200,000 Rand just to make the place like nothing. And then they just build over that again. And you're like, but it's the way it is.
Thanks, Bruno. Thank you, Silna. That was a very quick 35 minutes there. So, guys, I have an appointment with the beach right now. Bruno, you probably have an appointment with traffic, and Silna, your wine is waiting for you. But I just want to thank you guys for availing yourselves this Wednesday. As always, so interesting, so informative. And to our viewers, please, we want to see you next week. And please post the questions in the group so our experts can tackle them and we can ponder over them and give you the answers that you desire and that you seek. Everyone, thank you so much. Bruno, goodbye. Silna, goodbye. Cheers, guys.
Bye-bye, guys. Have a good one. Cheers.